Good morning, everybody, and we're going to begin our June 18th Friday meeting. Ms. Swan, could you please take roll?
Sure. James Bolton,
Here.
Michael Cow,
Here.
Alex Chen,
Present.
James Efting,
Here.
Karim Gongora, Dolores Heisinger,
Here.
Judge James Herman,
Here.
Michael Iseri,
Here.
Larry Kaplan, Paul Kramer,
Here.
Alex Lawrence,
Here.
Bethany Pick, Vince Reyes,
Here.
Judge Shelley Toliaba, David Torres, and Dr. Don Wilkerson.
Here.
We have a quorum, Ms. Chair.
Thank you, Ms. Wong. So it's time for public comments. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the public comments, written public comments. So we thank you for that. Ms. Wong will attempt to call members of the public in the order that they appear. Ms. Wong, how many commenters do we plan on having right now?
At the moment, we have about 3 who raised their hands. So let me call the first.
Oh, before we start calling. So due to the number of people requesting to make comments, we ask that you limit your comments to 2 minutes to facilitate hearing as many members of the public as possible. I encourage you not to repeat points that were made by previous speakers, and also to allow the committee the time needed to deliberate on the important topics that it will be discussing today. We will not be able to hear more than a maximum of 15 minutes of total public comments. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. And for those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. Ms. Wong, will you please call members of the public in the order that they identify with their raised hands?
Sure.
Thank you.
Ms. Hollett, you may start speaking now.
Hi, my name is Chloe Hollett, and this is with reference to the provisional license grant and review of the administration of the California Bar. I recently sat for the October 2020 bar and was awaiting my results. However, there seemed to have been significant inaccurate information, such as the grades being released a day after what would be registration for that upcoming April bar. I understand that the provisional license grant was offered kind of as a remedy during this pandemic. Many jurisdictions did just offer licenses directly. However, this provisional license grant did not include persons like myself who actually graduated law school some 11 years ago and just did not practice. I understand that there was a March revision. However, this revision was based upon scoring of the 2 examinations, and I didn't actually even sit for the, I guess, the February examination due to the concerns with reference to the release of the exams, the oversight of the grading nature, as well as some discrepancies with respect to cost, pricing, and communication with the admissions department of the California Bar. This was all sent via a letter dated January 18th to Ms. Wong, as well as the director of admissions. My request is for consideration and review of the provisional license. An extension of this provisional license to include those that were registered for the California Bar from October through the rest of the pandemic. And I do request that the committee consider that and then submit its findings to the California Supreme Court for modification of its rule.
Thank you for your comment. The next public comments is from Julian Sarkar. Go ahead, Mr. Sarkar.
Good morning. Thank you, Ms. Wong. My name is Julian Sarkar. As you know, I represent attorney applicants against the Office of Admissions Unlawful Activities. Today, I'm calling in response to Tammy Campbell's proposal, item 0301, that would allow her, the Office of Admissions, to sanction applicants and prevent them from disputing allegations or requesting hearings based on nothing more than unfounded allegations of something that they did not like purportedly about the video and audio surveillance of an applicant. For example, claiming that they could not hear that an applicant was breathing or typing through the microphone feed, and that they were therefore, they were not transmitting that audio feed. I understand that Ms. Campbell has since amended the proposal item after I submitted some written public comment to include another possibility. What if the Office of Admissions fabricated an unfounded claim that the applicant did not have enough disk space for the surveillance to work, even after the State Bar tested that equipment in a mock exam and told the applicant it was sufficient? In that scenario, Ms. Campbell argues the applicant should still not be able to dispute that unfounded allegation or request a hearing. I came here today to remind this committee that you are producing the next generation of the state's criminal prosecutors. And even as Ms. Campbell and her colleagues in the Office of Admissions are allowed to continue benefiting from the profits of defrauding those applicants, there may be longer-term consequences of your allowing them to do so. One day, your children might be defendants before this next generation of criminal prosecutors, and they will remember the processes that this committee enacted and made law. So in prosecuting your children, this generation of prosecutors, they will remember that when it became challenging to produce evidence to support their charges, this committee authorized Ms. Campbell to change the rules to make it so that no evidence had to be presented, and made it so that their unfounded allegations were just outright indisputable. This next generation of prosecutors that you are producing, they'll remember that the surest way to win at trial is to just change the law so that there is no trial in the first place and no need to present evidence. They will remember that, with reference to this amended agenda item in response to my written public comment, that when public scrutiny arises, the way to defend against it is to just fabricate more unfounded claims, such as those as you see in the amendment. Years ago, this committee denied.
Can you please wrap up your comments?
Thank you, Ms. Wong. I'm almost finished. Years ago, this committee denied Stephen Randall Glass admission to legal profession for making fabricated representations in a very well-known Supreme Court case. They had no truthful basis. But this committee allows Ms. Campbell and her colleagues to continue financially benefiting from engaging in similar factually unfounded fabrications, except that these actually directly harm people more than those fictional stories ever did. So I'm requesting that this committee reject that proposal and call for a resignation in order to protect the integrity of the legal profession and ultimately the legal system that's going to be left for your children. Thank you.
Thank you, Mr. Sarkar. Our next public comments from Benjamin Cohn. Mr. Cohn.
Yes, hello, thank you. I'm calling in reference to the same proposal regarding the Chapter 6 decisional matrix. I also would like to speak in favor of rejecting the proposed addition. I don't see how, if it was a traditional setting that was not remote, that 100% failure to verify that no cheating had occurred as an operational aspect on the state bar's side would result in these sanctions. And so I don't understand why they would be imposed for a remote exam. For example, if a proctor had to leave the room for some issue on their end, and there were a few applicants who had a few minutes that they were not being supervised, that would not normally lead to the invalidation of those applicants' exams. It's not something that's on their end. But in this instance, it seems to be that the position of the new rule that's being proposed is that if there's not 100% verifiability for any reason, even something that's predicated on being entirely the state bar's operational issues, then those applicants would have their whole exam invalidated and would have to retake entirely at their own expense, entirely at their own consequences of the delay. The more likely explanation of such an audio or video failure than any system requirements issues for the modest requirements that are published compared to normal laptops is just that ExamSoft, like most software, has bugs and glitches, and those will on occasion inevitably produce such issues. But not having 100% verifiability and needs to have be weighted against the consequences to the applicant. Their exam security should not be such a sacrosanct interest. It's a legitimate interest, but it shouldn't be so sacrosanct that it outweighs all competing interests at all degrees in all situations. People who are taking the bar exam.
Can you
Yes.
please wrap up your comments? Your
Okay.
time is up.
Okay. Sign an affidavit under penalty of perjury. They will comply with the exam rules. If there's no evidence that they would perjure themselves or had perjured themselves, the mere speculation that the bar isn't able to 100% verify that they hadn't objectively on their end is not sufficient to outweigh those other interests. Thank you.
Thank you, Mr. Cohn. Ms. Chair, I've seen no one else that raised their hands, so I think this is the end of the public comment.
Thank you. And thank you to everyone that took the time to speak with us today. We're going to look at the Committee of Bar Examiners public meeting minutes from April 23rd, 20 through 24th. Is there an approval or a motion to approve the minutes?
I'll make that motion.
Thank you, Dr. Cow. Is there a second?
I'll second.
Thank you, Ms. Heisinger. Roll call vote, please.
Sure. Dr. Bolton?
Yes.
Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman? Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Is this attendance or is this on a motion? Because I had to step away for about 10
Oh,
minutes.
this is for the motion for the open public meetings.
Yeah, I'll have to abstain. I wasn't here.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
Mr. Torres? Dr. Wilkinson?
Yes.
The motion passes.
Thank you. And at this time, I will turn this meeting over to Amy.
Good morning, everyone. I'm going to start with the update on the key statistical indicators report. What was attached to this agenda was a report for April 2021. The key statistical indicators report capture the number of applications received by the Office of Admissions to date, along with last year's count for a point of reference. The report also contains a number of petitions reviewed by the committee. And I like to highlight the applications with a 15% change or more when compared to the previous year. So in this report, there's a consistency compared to the last time we met when we covered this. Sorry, we met in April, and there's consistency in terms of the areas with a 15% difference, starting with the applicants placed on the motion. So there's an 84% increase in the number of applicants placed on the motion in the month of April. And this is primarily due to the fact that the October 2020 bar exam was postponed, and that delayed the results release to January. So that we don't anticipate having that increase in 2021. In terms of the registrations received, the number of law students is 19% more in the month of April 2020 when compared to, April 2021 when compared to April 2020. The same goes with the general bar exam. We have about a 28% increase compared to last year, as well as for those that applied as attorney examinees, 38% more compared to 2020. As for moral character determinations, we have an 18% increase when compared to 2020, which we believe may be related to the provisional licensing program. As for the moral character determination extension applications, we have about 17% less than compared to 2020. And those are the items that have a 15% differential when compared to 2020. Any questions? Okay, I'll go on to the next item then. Attached to this agenda is the schedule for August 20th, the CBE meeting. It's important to note that this is a 2-day schedule. We anticipate a second calibration for the July 2021 California bar exam on Saturday, August 21st. And we invite all CBE members and encourage CBE members to attend that second calibration session. Currently, the meeting and the calibration sessions are scheduled as Zoom meetings. And as a reminder, committee members are required to attend at least one second calibration session during their term. So just want to remind everybody about that policy and about and ensure that everyone's invited to that session. Any questions about the upcoming CBE meeting in August? Okay. Great, and with that, then we're going to get into the updates on.
Real quick, Amy.
Oh yes.
Is the I'm sorry. Good morning. Is the August meeting going to be in person or is it still virtual?
It's scheduled as a virtual meeting at the moment.
Okay, thank you.
You're welcome. All right, so we have a PowerPoint. I'm going to talk a little bit about.
I'm sorry, I have another question.
Yes.
How did we find out if we've attended a calibration? I don't even remember if I've ever attended one.
I could follow up with that, Larry.
Okay.
I'll follow up.
Thank you.
Sure. All right, so this next item is really, any other questions? Okay, this next item is related to the provisional licensing program. As you may recall, the program was implemented in November of 2020. Originally, the program was only open to law school students that graduated between December 2019 and December 2020. And these are law school graduates with an LLM or a JD. In February of 2021, eligibility was expanded to include bar exam applicants who achieved a score greater than 1390, the new cut score, either at first read or as a total scaled score between July 2015 and February 2020. And those eligible under this expanded criteria are also eligible to become fully licensed after 300 hours of work as a PLL, along with a positive referral from their supervisor in lieu of passing the bar exam. The application period for this expanded criteria closed on May 31st, 2021. And as of June 1st, we had over 700 applications received from applicants under the expanded category. What you have before you are the statistics for as of June 17th, 2021. As you can see here, we have separated the two separate categories. The first column here, for example, of approved applications, are those that have those that qualify for the program based on graduation date. We have a total of 444 versus those that qualified under the program expansion. We have a total of 482 and so on. So this is for the differentiating between those two criteria. And Audrey, you want to go to the next slide? And in sum, this is everyone who's participated. So we have a total of 926 approved active applications right now. The numbers related to those that have been terminated, people could be terminated for a variety of reasons. This includes they've advanced to become licensed, employment opportunities have changed, or they've shifted. We have people who have multiple applications, for example, people who've terminated and are now in a new position and have an approved application. So this is our total count as of yesterday. And also, I want to note that the program is still open. The application period remains open for those qualifying for the PLP as 2020 law school graduates. And the program itself is scheduled to sunset in June 2022. Any questions about the program or about PLP altogether? Okay. All right, wonderful. The next item I want to report on is the Blue Ribbon Commission on the future of the bar exam. The first meeting is scheduled to take place in July. It will be webcast and available on our to the public on our State Bar website. The meeting will be Bagley-Keene compliant. And the first meeting is really about highlighting the commission's charge, synthesizing information and data findings about bar exam related studies and concepts around the bar exam. I strongly encourage the CBE members to watch the webcast, whether you want to do that live when it's scheduled, or the recorded session, which will be available shortly after the meeting on the California Bar website. Any questions, concerns? Okay, great. All right. With that, then I'm going to hand this over to
me.
Audrey, you want me to run your slide?
No, I've got it. So the June 2021 first year law student exam is right around the corner on Tuesday. The 2 mandatory mock exams were due on June 11th, last Friday. Applicants have until Monday to download all their exam files, and this is just a count for you of how many total folks are taking the first year law student exam. And you can see how many, just a few people coming in the office to test because of extenuating circumstances or their accommodations. So about 9 writers between LA and San Francisco, and then 6 folks coming in person who are using their laptops. And then as you can see, the bulk of the rest are all taking it remotely. Any questions about the June exam? Okay, so next. Oh, come on. Okay, so we have the July 2021 California Bar exam coming up. The email updates and tips to approved and pending applicants will begin today and continue through the Friday before the bar exam. You'll remember we really have been trying to step up the communication. So every Friday, applicants are getting emails about deadlines and practicing the software, et cetera, and that's going to start today. We have 5,869 approved applicants as of today and 3,225 pending, so it looks to be a large exam. The final eligibility deadline for those pending applicants will be July 13th. Mock exams and admittance tickets will be available June 29th. The 2 required mock exams are due July 16th. Files ready for download the week of July 20th. ExamSoft has updated to version 2.7.2, which will include, among other things, and this is all on the updated FAQs on the website, but I wanted to highlight it for you. There will be warnings that pop up during the mock exams and the exam file download period when an applicant's device does not meet the minimum system requirements. And the performance test PDF is now searchable and highlightable and can be viewed side by side with the answer window. So those are some of the updates and improvements coming for the July exam. Any questions?
Hi, Audrey. Good morning. It's Kareem. I have a question on, is the intent to be remote here on out, or is this something that you foresee being phased out?
I can't really speak to that, Kareem. I know what what I know, which is the July exam will be primarily a remote administration.
Okay, thank you.
I have a quick question, Audrey. So the required mock exams are a function of the fact that the exam is being given virtually, right? There was no requirement that for mock exams before we went to remote.
Right, so the mock exams give the applicants an opportunity to practice the software, and one of the mock exams has old California questions in it, so yes.
Good, thank you.
Any other questions for me or for Amy?
Yes. But if somebody is taking the exam at a site but using a computer, would they be using the ExamSoft software?
Yes, but I believe there were mock exams associated with the laptop program before we went remote, but I don't remember. I don't think they were mandatory to sit the exam. So Tammy might have to help me because that was before I started, but I'm sure they had ways to practice Examplify if they were going to take it on site, but I don't think they were mandatory.
Audrey, I think they were mandatory. Christina can confirm. Yeah.
Yeah, mock exams have always been a requirement for anybody online or not online, on laptop. And so this isn't anything out of the ordinary of what they've done in the past if they've taken the exam before.
The difference is that if they were taking it at a test site, there wouldn't be the monitoring aspect.
Right. There was no, that part you wouldn't have to practice because there was no exam ID and monitor. There was no recording of the video because you were there in person. So that is different.
Thanks.
And I apologize. Thank you. Thank you, colleagues. That was before I was here. All right. I think that's all, Esther.
Oh, we have one item, sorry.
Oh, sorry.
Bethany was going to provide an update on the differential item functioning. And I think she is here, but if she's not available, I could provide that. So just to provide an update on where we're at with the differential item functioning working group, we are scheduled to meet in July. Currently, we're working in the subgroups to review items that have that were flagged with a high differential in terms of performance differential among some of the subpopulations. And the idea is to look at the patterns to start establishing these guidelines. So where we're at right now, I mentioned the working, there are small working groups that are meeting independently. We're all going to come together in July. So we should have more information probably in the fall about where we're at with the guidelines. Any questions? All right, wonderful. Well, back to you, Esther.
Thank you. We're going to move on to the examination subcommittee, Lisa and Jim.
Thank you, Esther. I think I'm going to be starting with the training, and Christina's going to be helping me run the PowerPoint. We have a PowerPoint on this.
Sorry, give me just one moment.
Okay, thank you. This presentation or this training is going to be about the grading of the California bar examination and the phase grading process, which was training that was requested by the committee last year, I believe. So the grading of the California bar exam We have teams of graders that are dedicated to questions. We have 6 written questions on the bar exam. That is what we are talking about today. And there are 5 essay questions and 1 performance test. So the graders, there are up to 16 graders per question. Typically, we would probably have 14, but the committee last year authorized us staff to, at our discretion, to go up to a maximum of 16 graders per question when the conditions warrant. They are all active California attorneys. We have a diverse pool of approximately 150 attorneys who are on in our grading pool. And each one of these grading teams has an additional 3 to 4 backup or apprentice graders per team. Those backup and apprentice graders typically do not actually grade, but they are involved in the calibration sessions and kind of part of the training that they would have, the ones that are apprentice. The EDGE team, the examination development and grading team, those are supervisors of each of those grading teams. And we have 1 EDGE team member per question who supervises. So there are 6 on the team, and they supervise only that question that they are responsible for. So what the EDGE team members do is they review and they evaluate the graders' analyses. They create tentative model answer and outline. They set tentative point allocations. They build consensus during the calibration sessions and outside of the calibration sessions, and they monitor compliance with the consensus. So this is kind of a little bit more detail on what the process is. The EDGE team, and as I just mentioned, the EDGE team member supervises, reviews the original author's analysis. This is the original author of the question. And then also the pre-test feedback. So each one of these essay questions is pre-tested prior to, as it goes through the editing process. And the EDGE team supervisor also does their own research, and they review the grader submissions. So the grader submissions are the graders independently. Each one of them researches the law. They draft an answer that's comprehensive, and then they review their fellow graders' submissions. All of this is part of the process of getting to know their questions and being very familiar with the law and the issues that should be targeted. Next, the EDGE team supervisor and the graders review the applicant familiarization answers. So what those are actual applicant answers, and they're given, I think, 5 familiarization answers prior to meeting for the calibration sessions. So the EDGE team supervisor then prepares a tentative model answer and outline, point allocation, and grading criteria to be used with holistic grading. So the calibration sessions, we have 3 of them. First calibration, what happens is the graders review the tentative model answer and point sheet. They get to group consensus by discussing the familiarization answers and the research that they've each done, and then they revise the model answer and outline according to what they come to in terms of consensus. And then they also, during that meeting, grade 15, an additional 15 applicant answers as a group, and they discuss any discrepancies and outliers, and all of this in an effort to come to calibration. After the meeting, each one of the graders will grade 25. These are another different 25 applicant answers independently. And then they do tentative grading. So they will assign grades, and then they submit those grades for calibration statistics that our psychometrician does for us. So during the second calibration session, which is generally, I think, 1 to 2 weeks later, they review and discuss the statistics from the tentative grading. They grade an additional 10 applicant answers as a group and discuss any discrepancies and outliers, similar to what they did during first calibration. So then at that point, after the second calibration meeting, they receive actual applicant answers to begin their grading. And then well, the other answers that they familiarize themselves with and calibrate are also actual applicant answers, but in this case, they actually start grading according to what they've been assigned. Third calibration, again, I think 1 to 2 weeks later, 2 weeks later, I think it is, they grade an additional 15 applicant answers as a group and discuss any discrepancies and outliers. They discuss any issues that they've encountered during the grading thus far. And they, all of this in an effort to ensure that the grader group is still calibrated after they start grading. So the grade assignments. Graders assign a raw grade from 40 to 100 in 5-point increments. In order to receive a 40, the applicant must at least identify the subject of the question and attempt to apply the law to the facts of the question. If the applicant's answer does not meet that minimum requirement, then the answer will receive a score of 0. So there are 2 phases of grading. We did used to have 3, but the committee decided to have a new 2-phase grading system. I think it was started, or you made the decision last year. So in first read or phase 1, all of the applicant's written answers are read at least once before pass-fail decisions are made. And so their maximum written raw score is 700, and that's 100 for each of 5 essay questions and 100 for the PT, but the PT is doubled. So that total 700 raw points. Then there's a total scale score. So the last slide I have has to do with the scaling. And so the scaling, well, we'll get to that. Yeah, okay, thank you. So after the raw scores are inserted into a scaling formula, the total scaled score, if it's 1390 and above out of 2000, the applicant passes the exam. And if it's below 1350, the applicant fails. Now this is the committee's, the Supreme Court's new pass score. The old pass score was 1440. The new pass score was directed by the Supreme Court. I think it was in June or July of last year. So, however, the applicants who score between 1350 and 1389.99, so just below the 1390 pass score, will go to phase 2. So phase 2, second read, the first read scores are hidden. The second set of graders, new set of graders, are not aware of the grades that the first set of graders had assigned. And then the first and second read scores are averaged to recalculated, and then again, the pass-fail decisions are made with the scaling formula. And 1390 and above will pass the exam, and below 1390 will fail, and that's the end of our grading. Next slide, please. So as I mentioned, scaling, everybody's excited about scaling, I'm sure. It's very complex statistical procedure that involves converting the sum of all the written scores assigned by the graders to same unit of measurement as that used for the multi-state bar examination, the MBE, which is the multiple choice part of the exam. This conversion is used to ensure that the applicant's likelihood of passing is not affected by any variation in the difficulty of the written section from exam to exam and across administrations of the exam. An applicant's total scale score is computed using a scaling formula, which varies from exam to exam. The National Conference of Bar Examiners, the NCBE, they score the MBE. They do own and produce and develop that exam. And they report the applicant's MBE scale scores to the individual jurisdictions. So we don't do any of that scoring. We do get the scale scores from the NCBE, and we use that information in developing our scaling formula, which is done by our psychometrician. Are there any other, if there are any questions? Christina and I are happy to field anyone who has a question.
Can I highlight one quick thing, Lisa, from your presentation?
Mhm.
You might going to the slide that has the different calibrations listed there for second and third calibration. Earlier, I highlighted that in August, we're going to have the second calibration. We're inviting the CVE. I want to highlight the activity that takes place at that session. Right there. Perfect. So if you look, during the second calibration, different exam, by each essay question, we go through 10 different answers and we prepare those booklets so everyone could follow along. So I just want to highlight that it's a great opportunity to learn about the grading process. Sometimes we get complaints or we hear about people feeling like perhaps there's a bias against them, like the school that they went to, their background somehow is impacted in the grading process. It's a very unique opportunity to learn about how the calibration happens, how personally identifying information is stripped from that essay. So again, I'm pitching it here to the group. It's a really wonderful opportunity. You will get the 10 answer essay books here, which is why we need to know in advance so we can prepare and ensure that we have CVE members in each of these groups. So more than anything, Lisa, I just wanted to highlight what activity takes place and what's more, invite the CVE to this really good opportunity on what takes place at our grading sessions.
Thank you, Amy, and also thank you for adding that the applicant's identity, any identifying information is removed from these answers. So they're completely anonymous in terms of the graders themselves not knowing anything about the applicants themselves when they do the grading.
I have a quick question. Typically, the committee is invited to how many of the 3 calibration sessions?
The second one mainly.
Second mainly.
Yeah, I believe that if you have, a desire to come to any of the other ones, if you let Christina know.
Mhm. So that would be an answer then to Larry's question. If he has no recollection of ever attending any calibration sessions, then he hasn't attended one. But if he has attended one, it was probably this one, the second calibration session.
Right, that one is the one typically that the CBE members are invited to.
Okay.
But just as a reminder, when these were in person, we did them off-site, so that might jog your memory whether you participated or not. And I also want to clarify that we're suggesting that all CBE members come to at least one. We're not limiting it to one, so you're welcome to join all of our future second calibrations as long as you're a CBE member. So just want to clarify that as well.
Yeah, I remember going to one that was at some hotel down the peninsula, like in San Bruno or something. Yeah.
Yes, that's it, Larry. So yeah, but everyone's more than welcome to attend.
Are there any other questions? I don't see anybody else. Okay, thank you, everybody. So I think the next item is the Supreme Court report. And Jim, I think you wanted me to take that, right?
Correct. Thank you.
Okay, so let me just get to my, the State Bar Rules 4.60B requires the Office of Admissions to provide the Supreme Court with Office of Admissions and the committee to provide the Supreme Court with a report on each administration of the examination of the exam. And we typically will provide the committee with a draft report for you to review and approve. And we do also have all of the attachments ready for that were posted. And so I'm happy to answer any questions about the report. I'm not going to, summarize the entire report, but there are a lot of numbers in it. And there are several attachments. So if, but I'd be happy to answer any questions anybody has about the report. Okay, I don't see any questions. So the motion that is up for the committee, Christina, if you could share that for us. It's a pretty straightforward motion.
Do you want me to just read it?
Sure.
Okay, so
Yeah.
I make a motion that the draft report to the Supreme Court, or the draft report to the Supreme Court report on the February 2021 California bar examination be approved and submitted to the California Supreme Court.
Okay, I just wanted to also, sorry, Jim, point out that there was one, is that the right motion? Yeah, sorry, there is one typo that I think Christina took out. It was in the actual agenda item, I had put that the draft report to the Supreme Court report, sorry, the draft report to the Supreme Court on the report on the, so you can take out that second report, and that she's corrected that. So that's the motion right there on your screen.
That's the motion I'd make.
Second.
Thank you.
we-
Roll call vote. Oh,
Go ahead.
roll call vote since Mr. Efting made the initial motion and Mr. Kramer made the second motion.
Sure. Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora, Mr. Gongora, Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak, Mr. Reyes,
What? My apologies. I'm going to interrupt real quick. Ms. Peak is having audio issues, so she typed her vote into the chat function, which is a yes.
thank you, Ms. Chair. Mr. Reyes,
Sorry, I don't know if that, will satisfy, because the public can't see the chat function that says the yes vote. I'm not sure we should count that one. Thank you.
Can I have a proxy?
Let me research the Robert's Rules of Orders real quick and get back to you. No, I would just not, yeah, I would just not count it for now. And if it doesn't pass, we'll retake the vote once she can call in.
will do. Mr. Reyes,
Yes.
Or not.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Corinne was a yes too. I don't know if you heard me.
I did not, but thank you.
Thank you.
Okay, thanks everyone. Sorry about that.
Great, thank you. So Jim, you're next up, I think, with the goals.
Okay, I have to figure out, how to get my screen so I can look at them. Okay, so agenda item 0 or open.201 is the examination goals. Goals 1, 2, and 3 and 4 have already been completed. Goal 5 was the training session we got today, so that takes care of that. Next month's training session is going to be on subject matter from a subject matter expert on the principles of scaling written test scores. So I encourage you all to come next month for that particular, or I guess it's August for that training. And then we have ongoing items 7 through 10. So does anybody have any particular items with respect to the goals for the examination committee? Okay, having no one having any more requests, there is a motion at the bottom moving that the report on the 2021 examination subcommittee goals be approved. Does anyone want to make that motion?
So move. This is Kareem.
Thank you, Kareem. There's
I'll
second.
I'll second that. This is Michael.
Michael, anyone, any more comments, questions? Can we have a vote then, please?
Yes. Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger, Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Pick, Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Thank you. So now it's time for operations and management with Tammy and Alex.
Morning, everyone. In a few moments, Ms. Campbell will provide more detail about the cost analysis report. And we did speak earlier this week about it, but I do want to bring to your attention the fact that the cost was higher at 1.75 million versus 1.475 million last year. And that was with a decrease in applicants of about 23.6%. Again, there's a lot of detail that's in there. I'm sure there's going to be questions even about the ability to say move to in-person, like, you know, I think is on everyone's mind. But like I said, Tammy can definitely provide more details about why those costs did go up as it relates to some of the individuals registering for taking the test in person and then possibly not showing up in many cases. So with that, I invite Ms. Campbell to add more detail and context to the analysis.
Thank you, Alex. So as Alex mentioned, for the February exam, there was the increase. Of course, continuing with the same format for the February exam as we did for October due to COVID, there was a shift in costs where we had some costs eliminated from doing it in person, but we also had other costs that were added in order for us to do the exam online and to accommodate for changes for any in-person applicants that we did have due to COVID. There was definitely a decrease in the number of applicants that we had this time around. We only had 3,530 applicants sit for the exam versus February 2020, for example, was 4,622. So that definitely makes a difference in the number of applicants. But because we do plan historically and we try to align all of our space requirements with the number of applicants that we had, for example, in October, and because, you know, it was an unsure thing where February would be, we could only picture it being similar to October. The amount of space that we ended up having at the in-person facilities ended up having less applicants than what we did even in October. And a lot of that shift is, you know, there is a provisional licensing program, so there's probably a decrease in our total numbers because of that. The other aspect is that there were requests from applicants last minute or throughout the process leading up to the exam to change from possibly taking it in person to taking it online. So that would eliminate in-person numbers as well. And then, of course, we also had not a large amount, but we did have some applicants who requested extenuating circumstances where we would provide them with a room for, you know, whatever reasons that they had provided. And they decided not to show up and take that test at home as well. So those are some of the varying factors where our numbers ended up being very, very low in person. And you're going to see on that cost analysis that the cost per applicant at the TA sites is a major increase from what we would have seen in February 2020. So with that being said, there were also a couple other changes for February, such as the MBE exams for October. The NCBE did not provide us with a full exam, so we did not pay for exams for the NCBE to be done online. However, because we're receiving the full exam this time, we did have to pay for the online exam for the MBE. So we've had some increases in the costs there for those factors. And as you see in the agenda, other things that still come into play. You know, we have a lot of personal protection equipment we had to send, and water bottles versus water stations. So all of those things were still in effect. So in the end, February 2020 was approximately $146 to administer for a general test center, compared to $2,430 for a testing accommodation site. And during the February 21 exam, it was $276 to administer online, which would be basically the general test center. And it ended up being $6,150 for each applicant at a TA test center in person, or extenuating circumstances as well. And so that brought down the overall cost for an applicant in February 2020 was approximately $319, compared to $495 per applicant for the February 2021 exam. So with that said, I will open it up if anybody has any questions.
Tammy, with respect to, say, for example, last bar exam that was administered, a 3-day exam, well, our last 2-day exam in person that was administered, I mean, we're still looking at a savings, is that correct?
I'm sorry, say that again?
There is a savings here doing it remotely as opposed to in person. That's continuing.
I mean, from the last exam to this exam, there might have been some savings, but I didn't see it being as huge as maybe some would think. It wasn't, you know, oh, there was a huge $1 million savings from putting on the exam to be doing it online. Now that we've had 2 exams, it makes it a little bit easier to now go back and really do some analysis versus online and in person to see how this balances. But yeah, there might be some savings there with doing it online, but because of the shift in other costs with doing it online, it's not rendering as much of a savings as people probably would have thought there would have been.
Thank you.
You're welcome.
So is it correct to state it at this point that it looks like it costs more to administer the exam online than in person? Just based on the information we have right now?
So looking at the February exam, it definitely costs more to administer this exam online than it did for the TA sites. I'd have to go back and look at October to see where those numbers fell. And of course, we also had the increase in the overall February exam costs based on the fact that we, you know, had all this space and we just didn't have a lot of applicants in person. But as of this cost analysis for February, we spent more to put on the online exam than we did the in-person. However, you have to consider, we would have normally had upwards of, you know, 10-ish test centers in person. So we have facility costs that we saved on in the in-person, as well as other things. So again, online is more expensive right now, but we did save on the in-person. So it's kind of hard to, how do you balance that, right?
Thank you.
You're welcome. So if there are any other questions that anybody has, but if not, Audrey, did you want to share the motion for the PowerPoint? So if there's no other questions, we do have a motion up on the screen that we ask that the committee move for the February 2021 California Bar Exam cost analysis to be received and filed.
So moved.
I'll second.
I'm sorry, who second?
Vince.
Thank you, Mr. Rios. Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Judge Herman,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson.
Yes.
I'm going to give a chance to Ms. Pick. Do you still have issue with your audio? The motion passes.
Okay, great. Thanks, Ms. Wong. The chair is having some internet connection, so I'll just take over until she comes back online. And so we're going to be looking at the next item on the agenda, 301, discussion and approval of addition of proposed sanction to the Chapter 6 decisional matrix. And again, Ms. Campbell can provide more context and information about the need to look at and do revision of the decisional matrix, Chapter 6, after review of exam videos from the October and February California bar examinations. Again, looking at some of the feedback, it was determined that we do need to make revisions to this decisional matrix. With that, I'll turn it over to Ms. Campbell.
Thank you, Alex. So as we are all aware, due to COVID, we had shifted to an online exam, which requires monitoring of applicants by video and as well as audio. We had come up with this Chapter 6 year.
Tammy, Ms. Campbell, you're
Lost
mute.
you.
Interesting. Okay, that turned off on its own. I'm not.
Ms. Campbell, you're off again.
Okay, let's try this one more time. Sorry, guys. I don't know what you just heard, so I'm going to kind of start over. Due to COVID, we have continued to do the online exam where we are monitoring the applicants by video and audio. And we came up with this Chapter 6 decisional matrix last year in order to assist staff with the review of these videos in making our determinations. Now, part of the online exam is that applicants have to meet the minimum system requirements for the program that they are using to work correctly. This item is
No volume, can't hear.
Yeah. Ms. Campbell. You may want to,
She froze.
yeah, Ms. Campbell, you may want to turn off your video. That might help.
Hi, I'm back again. Can you guys hear me?
Tammy,
Yes.
maybe try turning off your video and closing other applications because you keep freezing.
Okay, let me turn off my video. I don't really have any other applications open, so let me do that. Okay, so I'm not sure again where I left off. Audrey, what was the last thing I said?
The item.
Start all over. Okay. Due to COVID, we went to online exam, which was going to be monitored with video and audio for the applicants. We did a Chapter 6 matrix last year to help staff assist in, making determinations for all the videos that we were reviewing. And of course, part of the online exam is applicants have to meet the minimum system requirements. This item, as we mentioned already, is not about the internet connection because the internet connection is not required when the video is recording. It is about the insufficient RAM or hard drive space or a functional audio that allows us to be able to monitor the applicants in the way that we would need to. We, of course, did have applicants acknowledge to the testing conditions that they would meet the minimum system requirements. And this isn't meant to be a punitive change to the Chapter 6 decisional matrix. It's meant to come up with a fair and equal way so that there's no advantage for one applicant over another with being recorded for this exam and being monitored. If an applicant is not being monitored, there is no way for us to determine if they took the exam or what happened during the exam in order for us to carry out that monitoring function. This is also a separate category from the attempting to bypass the remote proctoring system, because that is actually a different category that does not revolve around having minimum system requirement issues. I would also like to note that the FAQs for the July exam have also been updated and to accommodate, to show some recent changes that have been made by ExamSoft that's going to assist the applicants in verifying they are meeting the minimum requirements. And I don't know if, Audrey, are you wanting to show that from the FAQs or? So this is the new information that is on the website for applicants to view that shows them the way that they'll be able to know that they're meeting the minimum system requirements. And if it's not being met, they will be notified. And they will have the option, I believe, a little bit further down. There's an option that, that will tell them if they're not meeting it, they still have the option to accept and continue, even if they're being informed that they're not being met. So this is giving applicants the opportunity to make sure they're meeting the requirements. And if they're not, they do have the ability to accept and continue, but that of course is going to be at risk of how that will, what the outcome of the monitoring videos will be. So with that being said, that's why we are asking for this new category for disruption of the video monitoring or audio to be added with a sanction of a 0 and with it being indisputable based on these new circumstances as well. So with that being said, I will open this up for comments.
I think that in looking at item number 1, second paragraph, regardless of whether the remote proctoring mechanisms are disrupted inadvertently or through an applicant's attempt to bypass those mechanisms, staff are unable to monitor going on, and for that reason, they would get a sanction of 0 for the session. I'm a little disturbed with that because I don't think that all the quirks have been worked out in the system. I mean, as an example, Tammy, we lost Tammy about 3 or 4 times during the course of her explaining the decision matrix due to audio. And, we never know what's going to happen during the course of a hearing, but I think that unintentional acts can occur, and I'm not necessarily, I'm really concerned about an applicant being sanctioned for that.
Can I ask a question? So Tammy, this an intermittent failure of somebody's internet connection isn't really the issue here. It's because the files are stored on the local computer during the test taking time, and they're uploaded afterwards, right?
That is correct, is that if they do not have enough space as the videos are recording to save them, that's the issue.
So David, it's not like what the experience, what Tammy just experienced as a failure. That's not the issue. Presumably somebody with a really slow connection would still upload the files after the test was completed, but it would be, it would just take longer than somebody on a faster connection. But, so many of the comments we received were, I think, had this basic misunderstanding about what the problem is. But Tammy, let me also ask you, have you investigated any of the technical issues that resulted in some people failing to be able to upload their files? Or is it just you just note that they never arrived and leave it at that?
So yes, we've had communication with ExamSoft with regards to certain circumstances to verify if there's any issues that we're not aware of, and that's when they're able to identify if they did not meet minimum system requirements.
And now, Paul, because of the changes that Audrey was showing that ExamSoft's made to the software, the applicant's going to be able to see that as well. And they're going to have to, affirmatively choose to continue with the exam despite the fact that they don't meet the minimum system requirements in order to, get through the mock and get through the actual exam.
Okay, but the actual item in red that's being added talks about disrupted video or audio during the examination. So to me, that's talking about a case where they did successfully upload the audio, but for some reason, part of the file's missing, or maybe the video goes blank for a little while, or the audio is muted. So are we talking about the same thing even?
Well, not necessarily, because an applicant can still continue with the mock exam and taking the bar exam, even if they don't meet the minimum system requirements. They're just going to be notified that they don't meet the minimum system requirements. So those issues could still exist going forward. Like that could still be the cause of the disrupted video or audio.
Okay, but but we've been speaking about this as if it was a failure to upload at all. And that seems different than what's described here.
Yeah, so if I may, I think sort of a couple of things, Paul, in response. First, there's a reason that so many of the initial public comments that we received were about internet connectivity, and we're confused about that point, and that was our fault. A prior version of the agenda item inadvertently used the word bandwidth, which of course suggests internet connectivity, and that was not the point. It was always sort of looking at this issue of whether or not we are receiving incomplete video or audio because somebody is not meeting the minimum system requirements. And so, the question for staff is, if that is the focus for not meeting the minimum system requirements, is there a way to clarify that in the decision matrix to ensure that everybody knows what is intended here?
Okay, so before we can decide whether it should be indisputable or not, I guess we need to ask, at least I need to ask myself, is there a situation that we can imagine where it would be acceptable to us that there was a 13-minute gap to go way back in time, the camera was covered for a little period of time? Could we imagine saying, no, that's okay? That seems to be the fundamental question here. Or should the test takers just suffer a 0 anytime there was a disruption in the signal?
Paul, to the extent that, the committee wants to discuss examination security, so that would include the implications of, somebody's video or audio being off, during some portion of the exam, I would suggest that the committee move into closed session to talk about that. We have a closed session item that is paired with this open session item. So the committee could go into closed session, talk about it, come back and vote on the matrix. But I think what you're saying implicates, examination security for the remote exam. So is better probably discussed in closed.
Caroline, can I ask you a question? Maybe I'm still a little confused about the issue. So clearly when an applicant downloaded the software ExamSoft and it runs the software, it will tell you whether there's sufficient memory or hard drive space, right? It will tell you. If you don't, then you don't meet the minimum requirement. Then ExamSoft will tell you, well, either get a new computer or do something so that you're now above that requirement, right? That is not an issue. When I'm looking at this latest revision, it seems to me that like we're trying to address an issue that is something happens in the middle of an exam whether an applicant does something to the camera or does something to the audio feed that basically blocks ExamSoft from the monitoring. Am I correct? Is my assessment correct? That is the issue that we're trying to address, or are we
No,
addressing?
so that issue is already addressed by the matrix. Attempting to bypass the video or audio, affirmatively attempting to do that is already an indisputable sanction that results in a 0. This is really about, other disruptions to video and audio. Like, they may be inadvertent, they may be intentional, but the idea behind it is that whether it's inadvertent or intentional, it deprives staff of the ability to monitor a person taking the exam remotely. And because this is a remote proctored exam, it's very different than an in-person exam. The only, tools that we have to monitor applicants are videos, are web cameras and microphones. So
an example that you have seen where the applicant has bypassed successfully, inadvertent or not, that has blocked our access to monitoring the exam.
For example, if somebody, turns off their web camera in the middle of an examination, that would be an attempt to bypass, right, the web camera and the remote proctoring protocols. But there are other reasons why your web camera might be disrupted, such as you don't meet the minimum system requirements. So this is intended to address those types of situations.
But I think now we're getting into, well, we're trying to come up with a single specific rule that addresses all the circumstances, right? But I'm not sure there's going to be a one-size-fits-all solution here, given that have been a lot of public comments on this issue. And realistically, there are applicants that have stated that, sometimes things happen that are not within their control. And in this instance, I can certainly understand if an applicant turns off the camera willfully, right, just so that they can go around and cheat. Of course, I think the decision matrix we should everybody have something that addresses that circumstance. But what if something happens where maybe the computer just experienced a glitch, right? And I certainly have experienced that when I did the mock exam last year. It also happened to me. And I know ExamSoft, if something happens, it will tell you to either log out and log back in again, or restart your computer, just so that the software can get restarted and jump started, and hopefully that will cure that problem. But I think here, if we're trying to be over inclusive, to trying to weed out or penalize applicants, for something like this that are not within their control, I just don't think this revision is fair.
I would say I do think Paul had raised a good question, but I still think it's probably more appropriately discussed and closed, which is, I think that the committee would need to consider whether something happens as a result of an applicant's, intentional act or unintentional act, is any amount of unmonitored test taking from a person's home and acceptable, is that acceptable from a security standpoint?
Well, I think that the most fundamental thing here is, under this matrix, it says the sanction is indisputable, meaning the committee itself can't even review when somebody gets flagged for this issue. So I wonder if, maybe the computer or the state bar can reconsider allowing applicants who actually have reasons to dispute and to file an appeal to do so. Otherwise, right now, they don't have any mechanisms or safeguards in place to protect their interests.
Yeah, and I'll point out that the attempt to bypass is not indisputable in this matrix. If you scroll up a ways.
Sorry, Paul, you're right. I misspoke. It is disputable. It is an automatic 0 sanction applied.
But then they can appeal it.
Right.
I have a question, and I'm sorry I missed some of this conversation. Precisely in relation to the question I'm going to ask, what about something totally beyond their control, like an internet outage? I have AT&T broadband, okay? What happened? There's some guy across the street, with a control box, and my internet goes down. I have no control over that.
When you're in an active exam session, Larry, you're not using internet.
Yeah,
So it's not about internet connectivity at all. It's about whether or not you have an issue related to your video and audio outside of the internet connectivity. And then, like I showed, you will be getting in this new version of Exemplify warnings when you don't meet the minimum system requirements. And we will know when you affirmatively say, I'm fine with not meeting the minimum system requirements.
So how do we know that somebody has their camera turned off? We don't know it. It's not real time then. We don't know it until later, correct? Because we're not.
Well, yeah, you mean the video, if we have videos uploaded that have no feed, then we'll know that there was nothing recording.
Right, so we're not connected to them live. In other words, correct?
No, it's not. Live streaming requires internet, like what we're doing now.
Okay, right.
And that's not how the exam sessions work.
Okay, so we don't know, and what's the time lag usually between us finding out that somebody had their, camera turned off and when it actually happened? A week, 2 weeks, what is it?
So they have to upload all their video files by the following noon on the following day after the second day of the exam. And then ExamSoft reviews at their level, and then we have the videos to review at our level. Probably, you're right, probably 2 weeks.
So let me interrupt here because I fear we're getting way too far afield because, and this really could have been worded better. The issue and the reason that Audrey showed you what's in the FAQs about the applicant will get a notification from ExamSoft that they do not meet the minimum system requirements is this, and I totally see where you're going, sort of as worded. I can see why your thinking is that the sanction could be imposed against somebody who had no idea, right? This was inadvertent. But what we're really talking about here is somebody who does not meet the system requirements. And they are now getting told that by ExamSoft during the mock exam. They're getting told that, Audrey, I believe at the start of the actual exam, that they do not meet the minimum system requirements. They have that information. If they choose to go forward anyway, then they are making a choice to submit submit something that may not have some audio or some video attached to it. So that's really what we're talking about. We're not talking about somebody whose internet goes out, somebody who inadvertently something happens completely out of their control and their audio stops working, right? That's not what we're looking at here. So I want to make sure that the analysis that you all are going through is it ties back to what staff was intending, and certainly we can sort of rephrase the item in this matrix to make that clearer.
I think that would be important because we got to know what we're going into and let the applicants know. For example, on the mock exam itself, that's done with sufficient time to allow this individual to upgrade their system, I presume.
Yes, absolutely. And this time they'll actually, well, I can share it again. They'll actually see exactly like what they have available on their personal system and how much is required for the software. So it'll be pretty precise.
I have a follow-up question to that. Is when they take the mock exam, is that the time they're notified about whether or not they would have the appropriate system requirement? Or is it before?
Well, they wouldn't. That mock exam is when they'll be installing the software on their laptop, and then they'll be getting those warnings.
So that's when they find out.
Yeah, and also, I mean, if they continue to not do anything, there's going to be other warnings when we actually have them download the exam files. So there'll be sufficient, from my understanding, sufficient warnings multiple times that they have to accept that they don't meet the requirements.
Okay, and then what's the time between the mock and the actual exam? I'm asking how much time do they have to upgrade their system?
Well, Audrey, let me add to, they also get notice of what the minimum system requirements are outside of the mock exam.
Oh, yes.
They have access to what those minimum system requirements are as soon as they apply for the exam.
Yeah,
so
and it's on the today's Friday email that I talked about. We're sending out, we try to we've tried to really send a lot of increased communication about what you need to be successful with the remote exam.
Okay, excellent. And so if someone does not meet those requirements, what physically do they have to do in terms of, can they somehow add more memory, or do they have to buy a whole new computer? There's also some cost involved in, being able to upgrade. That might be a deterrent for some people.
I mean, they usually have to delete off of their computer they're using to make more storage space.
Okay.
And Vince, they always have the option of applying as an extenuating circumstances applicant. Those are applicants who don't have access to the equipment required to take the remote exam. So they would not be deprived, the ability to take the exam. They just may, need to take it in person, either as a handwriter if their laptop doesn't meet the minimum system requirements, or, exactly as an applicant who couldn't meet the minimum system requirements before when we were in person with a laptop would do.
Yeah. Okay. No, these are excellent clarifications. So I'm just trying to see if the way things are worded will, takes into consideration all of these other options that people have to keep the playing ground level.
And just to your question about timing, so the mock exams open June 29th and then they close July 16th. So that's a lot of time to be able to see what you might need to do to make more storage on your laptop to meet the requirements.
I see.
I
That's
have a
good.
question. I have one question. Am I muted?
No, you're good, Dolores.
Okay. How many instances of this have we encountered so far?
That is something we would discuss in closed
Closed,
session
yeah.
as an exam security issue.
Okay.
So if we want to hop into closed, if there's a will to do that, we can do that.
I would hope we go to close. I really would like a numerical attribution to this amount, just to see what our impact would be.
Madam Chair, so given all the number of questions and also sort of ideas about from a wording standpoint, I think it would be prudent for us to go into close now and then return back to open.
Okay, so if everyone can just.
Is it easier to just put this later on the calendar so we don't have to come in and out?
That's fine, or it's also almost time for a break. So maybe we can go into a break and resume and close briefly, then come back to open. I mean, because we still have 2 more items on this, right?
Right.
If we want to continue with the rest of the open session, we could finish the open session and then, talk about this in close. And then when we come to adjourn, before we adjourn the open session, we'd resume the public part of the discussion of this. And then we would vote on, the committee will vote on what they want to do with the item. And then we can adjourn the meeting if that's easier, if that's another option.
Okay, so why don't we take a break, but stay in open. And when we come back, we will move on to item C, discussion and approval of proposed revision to the guidelines for foreign educated general applicants with the first degree in law. And we'll do just what Caroline suggested. It's 10:28 now. Why don't we come back at 10:40 and open?
Thank you.
Thank you.
Thank you.
Alexis, time is it?
Great. It's 10:40, so let's resume with item C, Tammy and Alex.
Yeah, great. So this is open item 302, discussion and approval of the proposed revision to the guidelines for foreign educated general applicants with a first degree in law. Again, I'm going to ask Ms. Campbell to provide more context and information and the details on this one. But this is an item that at a previous CBE meeting that we did have some discussion about. But the proposed guideline that we're going to be talking about will reduce costs, but more importantly, increase the flexibility for law students while maintaining the public protection as well. And with that, I'll turn it over to Ms. Campbell.
Thank you, Alex. So as everybody I'm sure has read this agenda item, some background is our foreign educated applicants who have a first degree in law are also required to meet a series of specific requirements that will allow them to establish eligibility to take the bar exam in California. And that's including that they must provide an evaluation by a credentialed agency approved by the CBE to determine that their degree, that their education is the first degree in law, and that it substantially is equivalent to a Juris Doctor degree awarded by a law school, approved by an ABA, or accredited by the CBE school. And on top of that, there's also a requirement that they would complete additional education in the Master's of Law degree, or LLM. And that requires that they would have been awarded a LLM based on a minimum of 20 semester or equivalent units of legal education. And that education would include no fewer than a total of 12 semester or equivalent units with a minimum of one course in 4 separate subjects tested on the California bar exam. And of those 4 courses, one of them is a requirement that it is the professional responsibility that covers the California rules of professional conduct and relevant sections of the California Business and Professions Code, as well as the ABA model rules of professional conduct and leading federal and state case law on the subject. And then of course, they also, if they've not been awarded the degree, as long as they've met the 20 semester or equivalent units of legal education in that LLM, that would qualify as well under that same minimum guideline of 12 semester units. In the past, if an applicant did not take the course at a law school that had been approved to cover the California components, the applicant would be required to take an additional professional responsibility course at an approved law school and at an additional cost in order to meet the California requirements. And some of the changes that have come up that has allowed us to put this on agenda and try to make a change is that, one, the original purpose for the current guideline is no longer applicable. The guideline was created at a time when the California rules of professional conduct differed from the American Bar Association's model rules. And in November 2018, there was a change to where now the California rules of professional conduct were enacted and adopted to align with the ABA model rules. So based on that, that was one thing that allowed us to look at this and say, okay, we can possibly change this guideline. The other aspect is this guideline will actually reduce cost and increase flexibility for law students while we're still maintaining public protection. Based on the fact that, you know, the current guideline does require law schools outside of California to add a significant amount of California content to professional responsibility courses. So with this going on and this change, we are able to say, well, is it really necessary for us to ask for the professional responsibility course to still require this level of California conduct? And it's not, and it actually benefits the applicant because we're not going to ask these applicants to go back and take another professional responsibility course, which is additional cost out of their pocket. So I think this change would be beneficial for the applicants as well as the Office of Admissions. So with that, I'll open it up for questions.
And Tammy, before that, you mentioned about cost, the additional cost for the individual to take this, that would be removed. In your experience, how much would possibly, you know, that individual save in that amount?
So I'm not sure an exact cost. I'm sure it can kind of vary a little bit across different schools, but I've heard that it can be upwards of around $2,000.
Great, thank you.
You're
And
welcome.
so want to open it up for discussion. Maybe I see Paul's hand raised.
Well, I didn't, but I do want to. Yeah, I had some, I support the concept. I just had some clarifications to make, to suggest to the language. So let me share where I jotted those down in a, where is it? Word document. Hold on, I have too many documents open. There it is. So I noticed that we use the word should, and are you seeing this?
Yes.
Because I can't see. So
Yes.
in A and B, and this is the attachment at the very end of Tammy's staff report, but this is the operative language. So A and B both currently say that the professional responsibility courses should contain various things, but that's, I think literally that's not a mandate, and we mean it as a requirement. So I think we should change the two instances of should to shall. And then the final paragraph is meant to say that courses that were taken previous to this change in our rules, which would not have satisfied our requirements at that time, can now be used to satisfy the requirements, because we've removed the requirement that there be California specific standards. But the language that's in there right now, I don't think makes all that clear. And I'm in favor of guidelines that are clearly explaining what we're doing and what we're thinking. So I tried to rewrite that to, as you can see here, paragraph C, to be clear that we changed our rules, removed this requirement, but we're happy to take courses that are taken prior to it if they meet the current requirements. So maybe there's a better way to say this, but this is what I propose. Because otherwise people are, when I first read that sentence, I was wondering, well, what is its purpose? And it would require somebody to go back and look at the previous version of the guidelines to figure out what changed. And I don't think we need to make them do that. It might be hard to find, you know, I don't know that the legislative history on the bar's website is terribly accessible. This way they can read this paragraph and they know what's going on, and then end of discussion.
So
Oh, sorry, T. Just one point of clarification, Paul. So the way you've written C, I mean, it's suggesting that we're regulating the courses themselves, which we are not. We're not actually requiring that the courses that the law schools teach anything in particular. We're just saying that the applicant's not going to be able to, prior to June 18th, 2021, the applicant wasn't able to establish eligibility for purposes of this guideline unless the professional responsibility course that they did take included California. So I guess it's just it's a small distinction, but I want to make clear, you know, we're not in the business of changing or recommending course content for the law schools, and we're not prescribing anything to them. They can teach whatever they want. This is a matter of, you know, the applicant establishing their eligibility.
Okay, so does adding that eligible take care of your thought?
Or I think it would have to be reworded to say something like this guideline required that applicants complete a professional responsibility course that included California specific professional conduct rules in addition to the ABA model rules. Tammy, do you think, I didn't want to interrupt you before, but is that?
No, that's fine. Yeah, that makes sense. So I'm just kind of watching what Paul is typing to see how it flows as he's doing it.
Mm-hmm. I don't know if I stated it the most artfully either, but I just wanted to change the way that it addresses applicants as opposed
Well,
to.
point taken. I'm happy with this if you are.
I think that's fine. You know, it's effective starting today, moving forward, that any classes in professional responsibility period will meet the requirements, even if these classes were taken prior to June 18th of this year. So I think we're good. Does anybody else want to weigh in on that and just make sure we're all on the same page?
Tammy, just out of curiosity, these foreign educated applicants, they are required to take the NPRE and pass the NPRE, correct?
That is correct.
Okay. I don't see any issue with that then.
And then you just made me realize, David, when you said foreign educated applicants, we may want to specify this guideline required that foreign educated applicants complete a professional responsibility course, just in the first line of C.
Yes. Okay.
Yeah, because it doesn't apply to all applicants. So I don't know. That's
Okay.
just a drafting issue. So anyway, thank you for saying that.
I have a quick comment. Or I think I heard Dolores. Okay. Can you walk me through how this would work for an applicant who has difficulty with getting their documents? We've had that situation in the past and it's come up to us. Would this impact that process, or is that totally two different processes as a foreign educated applicant?
So, I mean, applicants who are taking this professional responsibility course are applicants who are, of course, are not saying that they're an attorney. These are applicants who are just showing that they have been educated in a foreign setting and that they ask for this credential evaluation to be done to show that their foreign education is equivalent to a first degree in law and equivalent to a Juris Doctorate. So in that aspect, yes, applicants still have to provide documentation to these credential evaluation companies. So if they can't provide the information to that agency, it depends on each agency, but they won't be able to get that evaluation done to prove that they've met that level of education. So obviously, if they can't get those documentation, that's going to be an issue. And then that comes back to where we need original documentation of transcripts or, you know, whatever documentation. So it does lead back to that. But in most cases that I've seen, they're able to get their evaluation and give it to us.
But in short, Tammy, this change doesn't impact that process. What this change does is make it easier for applicants to demonstrate that they've met the professional responsibility requirement.
Correct.
Okay, that's exactly what I was thinking, but I needed the clarity. So I appreciate it. Thank you for the thoroughness.
At this time, I move that the Committee of Bar Examiners approve and adopt the revision to the guidelines effective June 18, 2021, and applicable to courses taken before or after the state for applicants with a foreign law degree for admission to practice law as set forth in the attachment
As modified.
as modified.
Second. Second.
Thank you. Roll call vote, please.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
And Paul, can you please send me that language so that I have it to put into the guidelines, please?
Sure, I'll send it to you and Kim for the minutes.
Perfect. Thank you so much.
Okay, the last item is 303, a report on the 2021 goals for O&M. There are no new additions, so everybody does have a copy that they can review. So are there any questions or comments? Seeing or hearing none, is there a motion on the goals for approval?
Yes, I'll make that motion. This is Michael.
Dr. Cow,
Yes.
and who second?
I'll second.
Dolores, thank you.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Thank you, everyone. I'll turn it back over to Madam Chair.
Thank you. Thanks, Alex and Tammy. We're going to move on to educational standards with Paul and Natalie.
Okay, thanks. First item is discussion and approval of a major change request, the addition of a hybrid GD program to Lincoln Law School of Sacramento. It's attachment O-400. Lincoln Law School of Sacramento is seeking approval to add a hybrid classroom and online JD program to its existing classroom-only program. This program would be approximately 75% online and 25% in person. The school has approximately 240 JD students in 2020. It's accredited by WASC, and in 2020, its last reported MPR was 60.1%. Staff reviewed the application and finds that it appears to demonstrate that the program will comply with the accredited law school rules. They recommend approval of the program, and I'll note that their proposed motion includes periodic status reports, including a discussion of an evaluation of the program's performance after it's been going for a period of time. We're happy to go into more details if anyone has any questions. Do we have any questions? Seeing none, can you put up the motion, Natalie? We see it.
If there's no comments, Paul, I'll make a motion to approve this action on request for major change.
Okay, one last chance for any questions or comments.
And I'll
If not-
second that.
Okay, thank you, David. Roll call?
Dr. Bolton,
Yes.
Dr. Kao,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, thank you. Our next is 0401, and that's a progress report regarding periodic inspection recommendations from San Francisco Law School. Previously, we inspected this law school, and we had a series of recommendations for actions to improve the program and also to maintain or come into compliance with our rules regarding the school. They were required to file periodic reports this year. The first was on May 15th, and the second will be due on November 15th. You have that before you. I don't have any specific highlights to make unless Natalie does. But does anyone have any questions about any of the aspects of the report? And Natalie, did you want to highlight anything?
I think maybe just generally to say that the school needed to take a lot of actions very quickly. And in the past, there was a question about a consistency issue. So this report was very helpful in encouraging the school to not only make progress, but really do so in a sustainable way that will maintain that progress. And that's what they're demonstrating in this report. So the committee's choice of follow-up, I think, has been very effective.
Okay, thank you. If there are no questions or comments, can you put up the motion, Natalie? Do we have a motion?
We do. Can you see it?
Yeah, I was wondering if somebody wanted to make it.
So moved. It's Alex.
I'll second. This is Vince.
Dr. Bolton,
Yes.
Dr. Kao,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, thank you. Item 0402 is a similar report from the People's College of Law. Again, they had a series of recommendations arising out of a previous inspection and were directed to report their progress on May 15, which they have done, and again on November 15. Did you want to highlight any particular aspects, Natalie?
It's really a similar situation. This school would improve but then those improvements would recede over the last 2 inspections, and this time we're seeing sustained progress. So appreciate the committee's selection here.
Okay, any questions from anyone? You want to put up the motion, Natalie?
I'll move to accept the report.
I'll second.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
Okay, next is 0403. That's a report on administrative updates at our accredited and unaccredited law schools. Yeah. Which is a report we receive at each of our meetings. There is one late edition, Natalie. You want to mention that one? It was came to our knowledge too late to include on here. The
Sure.
Lincoln.
Yes, so this relates to Lincoln Law Sacramento, the school that will be adding the hybrid JD program for the committee's permission today. Their longtime dean, Dean James Chavenza, has retired. He's here on the call, so I would just like to congratulate him on his successful service and wish him well on his retirement. The new dean, Philomena Yarashek, is a longtime teacher at the school, and she began her tenure this week. She is also here. We welcome her and we appreciate her enthusiasm in getting up to speed on her new role, reviewing the newsletter, and asking many terrific pertinent questions right from the start. We wish her a successful term.
Okay, thank you.
And there's no motion associated with this item because it is a notice item. So we can move on to the next one. You're ready, Paul.
Sure. And that is our goals for the subcommittee. And I don't have anything specific to highlight, though we will. Natalie, are we going to be considering the potentially another extension of the online teaching authority at our August meeting?
I don't expect so at this time. Most of the California schools are going back to an in-person teaching. The Cal schools having an additional semester is more flexible than other California teaching. I expect rather that those schools that wish to continue with the online teaching will file motions by October 1st. And we've received the first of such motion that I think you'll see in August.
Okay.
Further public health complications, I think it's a return to normal.
Okay. Did anyone have any questions or comments or even suggestions for additional goals that we might want to think about? If not, the motion is to approve the goals.
I'll make that motion. It's Alex.
Thank you, Alex. Second.
This is Michael. For that.
Okay, Dr. Cow, thank you.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Mr. Rios,
Yes.
Mr. Torres,
Yes.
Dr. Wilkinson,
Yes.
the motion passes.
You skipped me.
Judge Toriyama, are you present? Okay.
I am.
Thank you. Okay,
Okay,
so your vote is yes?
My vote is yes. Thank you.
Okay, thank you.
Okay, that's it for us.
Thanks, Paul, and thanks, Natalie. We're going to move on to the last but not least, moral character with Bethany and Tara.
All right, thank you, Madam Chair. So going over the moral character goals, I hope everyone has had a chance to review them. Just a quick review, we're going to be receiving a presentation on explicit and implicit bias at our upcoming meeting. We have some additional items for presentations on court cases that are relevant to moral character determinations to help us in our appeals process, a PTSD training later this year, and then our ongoing training for relevant topics and administrative reviews. So unless anyone has any comments or question or wants to have a discussion, I will ask if anyone wants to make a motion to approve these goals.
Yeah, I will approve, move to approve.
Thank you, David. Do we have a second?
I'll second. This is Kareem.
Thanks, Kareem.
Dr. Bolton?
I do have a question on on the what did you say, PTSD?
Mm-hmm.
Is that with Justice Board?
Yes, it's my understanding that that will just be for the committee. Is that correct, Tara?
Yes, that'll just be for the committee, and then we can always have staff attend if we'd like, but.
Dr. Bolton?
Yes.
Dr. Kao?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Toriyama?
Yes, sorry.
Mr. Torres?
Yes.
Dr. Wilkinson?
Yes.
The motion passes.
Thank you. So that concludes open for now. We will resume with open and have further discussion on item 301 under operations and management. So for now, can all the members and State Bar staff please go to closed session where we will begin our closed.
Okay. Okay, hello everyone. We are returning to open session, and Ms. Wong, can we get a roll call, please?
Sure. Dr. Bolton? Dr. Kao?
Here.
Mr. Chen?
Here.
Mr. Efting?
Present.
Mr. Gongora?
Present.
Ms. Heisinger?
Here.
Judge Herman? Mr. Iseri?
Here.
Mr. Kaplan?
Here.
Mr. Kramer?
Here.
Mr. Lawrence?
Here.
Ms. Peak?
Present.
Mr. Reyes?
Here.
Judge Toriaba?
Here.
Mr. Torres? Dr. Wilkinson?
Here.
We have a quorum.
Thank you, Ms. Wong. So just to bring everyone up to speed, this morning we did pause on the open agenda item, discussion and approval of the addition of proposed sanction to the Chapter 6 decisional matrix. I want to open it up to the committee for any further comments and or a motion.
So this is Jim Efting. I have some concerns about the motion as proposed because I believe it's a little bit overbroad. And so my motion would be that the Committee of Bar Examiners approve and adopt the revision to the administrative hearing outcomes decision matrix for use to assist in decision-making for staff determinations, administrative hearings, and appeals to the Committee of Examiners pursuant to Chapter 6 of the admissions filings, but that subject the most recent proposed change to only those applicants who have chosen to use a laptop computer and have been told when applying that their computer does not meet the minimum requirements for ExamSoft. I think that's correct. If any clarifications needed, please let me know. And there may be no second to that.
Thank you, James. Is there a second to that motion?
I'll second that.
Ms. Wong, can you take a vote, please?
Yes. Dr. Bolton?
Yes.
Dr. Kao?
Yes.
Mr. Chen? Mr. Efting?
Yes.
Yes, for
Mr.
Alex.
Gong? I'm sorry?
Yes, for Alex.
Okay. Mr. Gongora?
No.
Ms. Heisinger?
Yes.
Judge Herman? Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer? Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Peak?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
Mr. Torres?
Yes.
Dr. Wilkinson?
Yes.
The motion passes.
Thank you, Ms. Wong. I believe the meeting business has concluded.
Oh, Alex, sorry.
Oh.
So Audrey had pulled up the motion. James or Jim, I'm sorry. I called you by your formal name. Could you just make sure that that accurately reflects what you stated?
I have to read it here a second.
Okay, yeah, take your time. We want to make sure it's
I
right.
think I might have missed a word. So please tell me if it matches.
Jim, can you please read it again so the public can hear?
Move that the Committee of Bar,
We'll make sure it's right first. Sorry, Kim. I want to make sure that we have the wording correct.
it says when the applicant doesn't meet the minimum system requirements. I think the applicant's computer does not meet the minimum.
I don't know if you want to say laptop, Audrey, just to be.
Okay.
Okay.
Okay, so I believe that's correct. Move that, and there's two that's there, so I think there will be one that at the top. Okay, move that the Committee of Bar Examiners approve and adopt the revision to the administrative hearing outcomes decisional matrix for use to assist in decision-making for staff determinations when an applicant's laptop does not meet the minimum system requirements, administrative hearings and appeals to the Committee of Bar Examiners pursuant to Chapter 6 of the admissions rules.
Yeah, that's not right. That's why I was thinking there's something weird here. We tried to limit it,
Right.
but Audrey, it's a list there. So, but we get the meaning. As long as, so we're limiting the existing staff proposal to only those applicants whose laptops do not meet the minimum system requirements. And I think we understand all the rest of it. I just want to make sure.
Okay, so we want to ask, does anybody want to change their vote?
I don't want to change my vote, but this doesn't say anything about whether it will be disputable, indisputable, or whatever.
The proposal said it was indisputable. So the indisputable applies when the applicant's laptop computer does not meet the minimum system requirements.
I don't see the word undisputable anywhere here.
It's actually in the matrix itself that we're approving.
So it's not in this motion, it's in the attached matrix.
Okay.
So yeah, the motion is to adopt the matrix, the proposal for the change to the matrix as revised by the committee. And the revision by the committee is to limit it to only those situations where the applicant's laptop doesn't meet the minimum system requirements.
Okay.
I have, is there any place where the minimum requirements are identified?
Yes, it's identified in what they sign when they apply and accept the tests and conditions. It's identified in the FAQs. It's identified in the emails that they get weekly leading up to the exam. It's identified in several different places.
Good enough. Thank you.
Thank you.
And just for staff purposes, we might want to revisit this after the next exam to see if it needs to be tweaked.
That makes sense.
Great
Great.
suggestion, Jim.
Yeah, good suggestion. Okay, now I think the meeting business has concluded. Is there any more business? Otherwise, thank you, everyone.
Have a happy Juneteenth, everyone.
Happy
Okay.
Juneteenth.
Absolutely. Can you remind, when's our next meeting? What date?
August 20th and 21st.
Perfect. Okay. Thank you.
So happy Juneteenth, 4th of July, and any other holidays that come up between now and then.
Happy Father's Day to.
And happy
Absolutely. Happy Father's Day to all the dads and Juneteenth and everything. Bye, everybody.
Bye, everyone.
Bye, everyone. Take care.
Thank you. Bye.